And today, former FBI Director James Comey will try to get his indictment dismissed in federal court. Comey's accused of lying to Congress when he testified that he never authorized other FBI officials to leak information to the press. Earlier this week, a magistrate judge raised a concern about a, quote, disturbing pattern of profound investigative missteps in the case. Federal prosecutors appealed, arguing that judge exceeded his authority and failed to show the government's conduct was improper. Now, Comey's lawyers are asking a federal judge to dismiss the case, saying Comey's only indicted because he criticized the president, while prosecutors say Comey can't prove the case was brought solely to punish him for his criticism. Let's bring in ABC News Washington Bureau Managing Editor Catherine Faulders from outside the courthouse and ABC's legal contributor, Professor at Hofstra Law, James Sample, for more. So, Catherine, start us off. What's the latest from court, and what can we expect today?
So court should be underway as of just a few minutes ago here. We expect that James Comey will probably be in court for this. So remember, this judge is hearing arguments on a motion that was brought by Comey's defense attorneys that claim that Comey was selectively and vindictively prosecuted. Now, what do they mean by that? Of course, they've cited Trump's own words saying that Comey should obviously be investigated, and the fact that Trump appointed his former defense attorney, Linsey Davis, to the post, who brought the indictment shortly thereafter. We'll see what this judge says. He could possibly throw out the case based on these arguments. We don't know if he'll rule from the bench or if he'll obviously submit a written ruling after the fact, but we could possibly get a roadmap for how this case will progress down the road, if it will at all.
James, Comey's lawyers argue he's only being prosecuted because of his criticism of President Trump. The prosecutors here say the motion falls short of the high legal standard to prove a vindictive prosecution. So what do Comey's attorneys actually have to show in order to meet that bar?
Diane, what they need to show is that this prosecution is being brought regardless of the facts, that it's being brought despite the fact that there isn't a case, that there is a smoking gun, that this does rise to the high level of it being a vindictive prosecution, that but for the vindictiveness, but for animus towards the defendant on the part of the Department of Justice, and in this case, the President of the United States, this case would not have been brought. It is one prong of the multi-prong effort that James Comey is lodged to try and get this case thrown out before it even really gets started. And as Catherine's report just indicated, there are so many aspects of this case that indicate that it may be dismissed before it even really gets going. We're talking about the lawfulness or unlawfulness of the appointment. There are privilege issues. There are questions about misleading statements that may have been made to the grand jury. There may or may not be a question of missing minutes and a lack of record keeping during portions of the grand jury testimony. There is so much in this case that may prevent the case from ever getting to trial at all. The vindictive prosecution motion that is the subject of today's hearing is one part of that.
Catherine, a magistrate judge ordered grand jury materials be handed over to Comey's attorneys, but the federal judge blocked that order. So what are you watching for on that front?
Yeah, that will be interesting to see if this actually comes up during this hearing. I'm sure the defense will bring it up in some way, given that it likely plays into their arguments here. But the magistrate judge obviously is discussing that. I know that you mentioned the federal judge blocked it. It's just stayed for now, so we'll see how that progresses. But I can imagine it's something that will come up in this hearing today. Of course, the defense wants that because they want to file a motion citing grand jury misconduct. So we'll see, again, if it comes up. I can't imagine that it won't, though. So we'll let you know.
And James, what does the judge need to consider when it comes to turning over grand jury materials?
It is very rare for grand jury materials like that to be turned over to the defense, Diane. So the bar is high. And Magistrate Judge Michael Fitzpatrick, when he issued that order, said, look, I recognize that this is an extraordinary remedy. On the other hand, he said, in essence, that the circumstances of this case, that the flaws that he identified in the grand jury process are extraordinary. So the general idea of grand jury proceedings is that they are secret, and they are secret for very good reasons, for lots and lots of reasons. So it is a high bar to overcome. On the other hand, if you don't allow that bar to be overcome in certain extreme circumstances, then you're essentially incentivizing the kind of untoward and erroneous behavior that you don't want to be part of the legal process. So here the question is Either scenario is suboptimal. Turning over grand jury proceedings is extreme, but allowing for erroneous procedures in the grand jury process is also deeply flawed.
Catherine Falders, James Sample, thank you both.